Sure, shut up. If you ask me a question, I can't answer while you're talking.
No, I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black roll, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese? Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever had a grilled cheese?
other issues as well?
You're in contempt of
All right, guys. Today we got one of the most arrogant and disrespectful sovereign citizens we've ever featured. This man has an ego the size of Texas and flat out refuses to answer a single question from one of the best judges on YouTube, Judge Oakley. It's honestly insane how he thinks he can just ignore the law and play word games in court. But Judge Oakley, he handles it like an absolute pro, putting this guy right in his place. Watch closely. Do you think Oakley nailed it here? Or should he have gone even harder? Rate his performance 1 to 10 in the comments. And let's jump into one of the most chaotic court hearings I've ever seen.
defendant. Sit at the defendant's chair.
Sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen.
I'm not a sophist.
All right, sir, don't speak.
Maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it was Mr. Michaud's assertion. There is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, rule objections that are preserved on the record. If he has,
You can appeal me. I'll let you build whatever record you want to build, Mr. Shaw.
Are we on record?
Yes.
Are you going to use both the Constitution?
Hold on, what? Are you picking him up? That's one of the reasons I want you up here, so there's a microphone here.
I'll speak up.
Are you picking him up? Go ahead.
Are you honoring your oath to the Constitution?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
And
I took an oath that said I would follow the Constitution.
not uphold the Constitution.
Yes, follow the Constitution.
So you are upholding your oath to the Constitution.
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights and
I would have nothing less. Now, are you representing yourself today?
I'll present myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
All right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
And it could be available if you wanted to
Okay.
ask him to do that at the
Okay.
correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what I I've served notice.
Sir,
on
it's a
this
yes or
issue.
no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or no?
This right here is a problem with sovereign citizens. They twist courtroom rules like they're auditioning for some low-budget legal drama. It's fake, it's shady, and it's exhausting to watch. Look, if I were a sovereign citizen, which I'm not, I'd at least be respectful, so the judge doesn't drop a contempt charge on me. I'm not saying they're the worst humans alive, but come on, if they'd just show an ounce of respect, maybe, just maybe, they could walk away with a shred of dignity. But no, they refuse to answer even the simplest questions, and it's not going to help their case one bit.
You're forcing me to say answer.
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do. Yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
criminal
under the authority
or-
of the state of Michigan.
what is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What
And
is it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory. That is what, civil?
No.
So what is it? For
My
the record, I need to
jurisdiction
have
is
it
both
on-
civil.
I can't defend myself unless I have it on the record. Is it?
My
There's
jurisdiction.
only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
This is a criminal case.
okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. You don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I enter sworn.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
And here we go. This guy's claiming there has to be an injured party for his criminal case. Like, dude, where is your brain vacationing? Newsflash. In criminal law, the injured party can be the state itself. When you break the law, you're harming the public as a whole. That's why Judge Oakley told him, the people of Michigan are the injured party. It's like robbing a bank and saying, well, the vault didn't file a complaint, so I'm good. Ridiculous. Is he really this clueless? Or does he just enjoy wasting everyone's time?
The state of Michigan
how can I
are
enter
bringing
the
the
state?
charges.
How can I enter the
Sir,
state?
sit down. Sit
I understand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. This is a quick preliminary matter. We request a mutual order of sequestration with an exception for the
So-
OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at you. Would you mind putting your name on the record?
She's a witness. She is a
I-
witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What I'm supposed to?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Stephan. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a problem. This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
This is exactly why I love Judge Oakley. The way he handles these sovereign citizens is chef's kiss. He doesn't let them hijack the courtroom with nonsense, and he's not afraid to throw in some sarcasm when needed. Some people in the comments last time said he was too harsh, but I completely disagree. Sometimes firmness is the only way to stop these circus acts. Letting them run wild just burns taxpayer money. What's the alternative? Let them waste everyone's time and make a mockery of the court? Nope, not here.
Under what grounds am I denied?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid
I
objection.
object that we are having a preliminary exam when I haven't had a probable cause hearing, and I did not.
They're the same thing.
It's still on this.
Mr. Michaud. They're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different day that says preliminary
Have you
exam.
ever had a grilled
If it
cheese?
was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, at a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative. So he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way. But my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too. But I'm not going to talk over him.
Right.
And I'm not going to play that crap today. So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pre-trial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If this is a hearing.
You didn't waive it. There's nothing to hold.
I have the right to have a probable cause conference.
No. You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's
to
no
prepare,
preparing for a probable cause conference. It's a conversation.
it still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
I wish we could see this guy's face right now. The amount of time wasted on him trying to grasp the most basic concept, like a probable cause conference, is beyond irritating. It's not rocket science. It's literally just figuring out if there's enough evidence to move forward. But nope, he's acting like he needs a year to prep for the bar exam. And then the grilled cheese analogy? That had me laughing. I swear, Oakley must have been thinking, how do I explain this to someone with an IQ of -12? Do you think he's actually clueless, or just playing dumb to dodge the process?
Now, do you want to plead guilty? You want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he's ruled on his arguments, and if he preserves his right to,
He can appeal them.
as you've already said, in circuit court. So if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some. I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served the notice that I requested the criminal bonding information.
Criminal what?
Bid bond.
Hold on.
I requested the bid bond, the performance bond. I have the affidavits.
There is no bond.
There are bonds. This is
Okay, listen. You can't tell me something and then just disagree with me and think it. Listen to me, sir. I am not going to let you interrupt me.
No, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black roll. Okay? That's just the way it works. My courtroom, I get to.
This hearing should have been over 10 minutes ago. But here we are, watching this guy drag it out like it's his personal TED Talk. Sovereign citizens love acting like the judge is their private legal tutor, demanding explanations for things they should already know. At this point, it's either a mental block or a full-blown act. Honestly, if he interrupts one more time, a night in jail might be exactly the reality check he needs. What do you think? Should Oakley drop the hammer?
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you
Can
got
you-
in front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
Great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
the
any of that.
United States citizen. I am
Stop.
actually
Hold on. Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize it.
Under what law could you represent, or you can use, or tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean,
prove
hold on.
it?
It should mean something because,
Prove it, please. Prove
can I
it.
prove what?
Prove that I am not that I am the artificial person. Here
I
it
can
is.
prove you're
I
Frank
have
Michaud.
full faith and credit.
I can
I
prove.
have a so
Hold on, you've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
actually-
proved it
you
for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay?
you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus
Listen
you
to me.
have-
Mr.
you
Michaud,
have- you have
I've
multiple
wasted
laws.
too much time with you. Yes or
Okay.
no?
So
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
What?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days.
Boom. 30 days, just like that. If that's not a wake-up call for every sovereign citizen out there, I don't know what is. If you're going up against Judge Oakley, maybe hire a lawyer, any lawyer, because walking and thinking you can outsmart the system is a one-way ticket to a cell. My favorite part? When Oakley broke it down at the end and proved this guy was a person named in the case. You showed up to fight the case when I called your name. How much clearer can it get? This guy's ego trip ended exactly where it should have, in jail. So what do you think? Was Judge Oakley too harsh or absolutely fair? Personally, I think he was perfect. Let me know in the comments. And if you enjoyed this breakdown, hit like and subscribe. It helps the channel a ton. Thanks for watching, and I'll see you in the next one.